Okay. I have nothing on my monitor.
Same.
Same.
You did clarify that it should happen. It just sounds like it did.
Pushing buttons, it probably isn't allowed.
Yeah, I'm not gonna touch it.
This is the inaugural flight, so.
Yeah, no worries. You get it. Does that work for everybody? I don't think I can draw it up to your screen because of the way this system is kind of glitching right now.
Oh, okay.
Okay, yeah.
So this is kind of all that we have. I really apologize, I'm sorry.
All right, thank you. It should work all right.
Yeah.
Okay, so welcome to Division 1 of the Colorado Court of Appeals. We have one case on the docket this afternoon, Scott versus Montrose County Board of County Commissioners. As we all know, this is, I believe, the first trial of our new hybrid system, which allows counsel to appear remotely, while at the same time counsel appears in person. We're quite happy to have this system because it does allow us to be more accessible to the public throughout the entire state of Colorado. So yeah, this is the first time. Obviously hasn't gone off without a hitch, but looks like it's gonna be manageable. Okay, so like I said, we have the one case on the docket. You guys probably know the rules, 15 minutes per side. And the appellant can attempt to reserve time for rebuttal, but that'll of course depend on how the questioning goes. For counsel in the courtroom, the podium raises and lowers with a toggle switch, if you want to do that. Keep in mind that the arguments are live streamed, although I'm not sure these are being, there's some.
I think they are back to
They
being
are
live.
now, okay, they're back to that now, and are being recorded in any event for future reference. So if there's anything you need to say, you know, that you don't want recorded for posterity, just keep that in mind. Do you have any questions concerning our procedures?
Your Honor, I
Yes.
don't see a timer on my side.
Okay.
So I'll be winging it, I guess.
Okay, what I'll do then is I will let you know when you get to 10 minutes or 5 minutes left. So, because that's usually when the yellow light goes on, as you know. And unless you want to be told more often than that, which I can do, how much time you have. What would you like?
I think 5 minutes would be great. That's usually, yeah, like you said, that's when the light comes on, so that'll work.
Okay, good. All right, we're about ready to proceed.
Can I ask a quick? Can you see all of us?
I can see two of you
Okay.
and the podium.
And the podium, okay. We're making notes because we have some things to work out with this. So which two of us can you see?
I can see you, and it would be, I can't see the nameplate, but the person to your right, yes.
Okay, so the person to my right is Judge Welling, and the person to my left is Judge Schock, okay? But that must be, that's probably, well,
That is better.
I guess that's because of the angle of the screen we're using. And I don't know if that would be different, though, if we were able to use these screens in front of us. It probably would be. But we'll make a note of that, just to check that. All right, so I believe since there were no questions, we are ready to proceed. Counsel for the appellant, you are up.
May it please the court, my name is Damon Davis. I represent Natasha Scott. My attorney number is 34323. The question before the court is whether the ice on the airport ramp walkway was a dangerous condition that physically interfered with public access. And the answer is yes. This question is best looked at holistically. We know there is an accumulation of ice. We know ice is physical because it's a physical object. And we know it interferes with progress because it It's slick, you have to walk carefully or risk slipping. So the main question is whether the ice was unreasonably dangerous. Not only because it has to be unreasonably dangerous for there to be a waiver of immunity, but because if it is unreasonably dangerous, there's going to be material interference with the public access. The answer to the question as to whether the ice is unreasonably dangerous rests with three cases. On one hand, we have Mathis, which found no unreasonable danger. On the other hand, we have Martinez and Galef, which found that there was an unreasonable danger. And a careful review of these cases shows that this case is analogous to Martinez and Galef and should produce the same result. First, this case is distinct from the Mathis case. Hopefully I'm pronouncing that correctly. Mathis was particularly concerned with the cost and the practical impossibility of keeping all residential sidewalks like new, and especially given that sidewalk heaving is common in Colorado, and that you have to prioritize repairs, whether different sidewalks, different streets, or what have you. But here, the commercial aviation ramp, where the fall occurred, was already prioritized. It was a priority 1 area for snow and ice removal. It was supposed to be continuously monitored, and snow and ice were to be removed within 1 hour. Further, it is entirely possible to keep it clear of snow and ice because that is already a regulatory and policy requirement. That is what the airport is supposed to be doing already anyway. And the cost is reasonable because it's simply part of the airport's overhead. It's part of the cost of doing business for the airport because it is a regulatory and policy requirement.
Council, whoa, sorry, got some feedback. Given your argument in that regard, is it your position that any ice on that walkway would necessarily constitute an unreasonable or a dangerous condition?
Not necessarily. I think if the ice is there when nobody is scheduled to be using this walkway, if nobody's scheduled to use it that day and someone just happens to be walking by, that's a different scenario. But here we knew that the airport knew people were going to be using it at this particular time and place because of the airline schedule. So I think there can be circumstances where it's not a dangerous condition, but those aren't these circumstances.
But any time that it's going to be used, if there's ice on that walkway, it's a dangerous condition.
I think this particular walkway, yes, because of and if they know it's going to be used, because of the priority area where you're supposed to keep this free of snow and ice. And it's a reasonable cost to do it. And as long as they know it's there, I mean, that's part of the dangerous condition that wasn't addressed by the trial court. But yes, it would be a dangerous condition because of these risks presented by the ice and that are fairly unique to an airport walkway.
Council, I'd like to ask you about your reliance on the FAA regulations. Can you hear me?
Yes, I can.
Okay, good. It seems to me those regulations have more to do with whether there was a duty and what that duty was, as opposed to whether the condition itself was dangerous. In other words, the condition refers to the physical state of something, and the regulations don't really affect the physical state of the walkway. It's icy. Now, the fact that people have to walk on it and they can't deviate from that affects the physical state, I think, because they can't go around it. The daylight versus nighttime type issue would affect that because that would make it more risky. But I'm just having trouble seeing a link from the regulations to the risk. How do the regulations increase the risk and make it more dangerous?
I would say that the regulations go to not so much they go to the risk to the extent that people that regularly use the airport, if they know about the regulations, they would expect the area to be clear. So it goes to whether you're even expecting the risk to be present. And it also goes to some of the other concerns that the Supreme Court expressed in the Mathis case about the expense or the impossibility of keeping all sidewalks up to a certain level, because the regulations already require the airport to do that here, those concerns don't arise. So that does allow us to concentrate more on the risk factors, which are similar to the cases like Martinez and like the Galef case. I think that's where they come into play, is alleviating those concerns that the Supreme Court expressed with regard to a residential sidewalk.
Let me follow up with that. Does it potentially go to, it doesn't make it more or less dangerous, but it goes to the reasonableness of the danger that does exist. Is that your point with respect to the regulations? Because the existence of the regulations don't make it more or
That
less.
makes sense, yes. I think because they can address this danger, and it's not unreasonable to expect them to take care of that with regard to the airport.
And you
So I think
indicate,
that's a good way of putting it.
and you indicated that it could be, it could make it more dangerous if the user knows of the regulations and has some expectation. There's no such allegations of this in this case, in the declaration or the complaint, is there? Or am I wrong on that?
I don't believe there are allegations. I think you're correct. I don't think we put in allegations that Ms. Scott knew about the regulations.
Okay. And can you finish this sentence for me? Because I think the trial courts, my takeaway was, one of the problems is this is an allegation of mere existence of ICE. This claim is not based on the mere existence of ICE because. What else is here other than there was ICE on the walkway?
Because it was on a walkway that the airport knew people were going to be using at this particular time in place, and because people were required to walk across this particular walkway. And so they had to walk across the ice whether they knew it was there or not. And that makes it like, in many respects, the Martinez case. And in the Martinez case, you have this icy sidewalk going up to a school building that people were walking across in the evening to get to a school function. So the school knew people were going to be there, and you have this icy walk that people were going to walk across. And you have the same thing here. You have the ice going across the entire walkway, and they knew people were going to be walking across it. The additional factor you have here is if you're at a school and you have a sidewalk, if you see that it's icy, you can like walk around in the grass or the gravel. Snow might be less slick. You can avoid the ice if you know it's there. Here, Ms. Scott didn't have that option. And we don't really know how visible the ice was. The court said it was visible, but we didn't have a hearing on that. And I would say, again, you have the thin ice, is what the court said. This is thin ice, the trial court. If you look at it, thin ice is often harder to see than thick ice. And I think if you look at the pictures, if you don't look carefully, you can mistake it for water. You can mistake it for something else because of the thinness of the ice. But the thin ice is just as slick as thick ice. So it presents just as much of a fall risk as if there was a thick layer of ice. So you still have the same amount of danger that you had in the Martinez case, where it was found to be unreasonably dangerous and to physically interfere with public access.
Counsel, let me ask you about the lighting issue. In the trial court, in the motion to reconsider, you said that this was during daylight. And on appeal, you say it was not during daylight. You say it could have been 20 minutes before sunrise. And I know in your reply you say, well, it was a motion to reconsider and we didn't have to file a motion to reconsider. But the fact is you did, and you made that representation of fact to the court, and we usually take those as judicial admissions. So how would you get around that judicial admission?
Well, I would say two things on that. First of all, in the motion to reconsider, we're trying to address the order as the court has already issued it. The court had already said that. We're trying to persuade the court that regardless of what the court believes to be an undisputed fact, we still prevail. And so we're trying to address the order as it exists rather than concede a point. The other thing I would say is even if it is daylight, there are concerns about how visible the ice is, whether because it's black ice or potentially black ice, it's could be missed by somebody walking on it. So even if it is daylight, there's still concerns about visibility, and there's still the requirement that even if you do see it, you have to walk across it anyway. So it's not like you can avoid the risk, even if you do see the light.
Thank you. Just want to let you know there's 4 minutes left. When we started that exchange, there were 5. So now there are 4 minutes left.
On
So
that,
considering that I've got 4 minutes left, I'd like to briefly turn to the considerations that were in the Galef case, which came out after Mathis.
actually,
And
counsel,
that's the-
because of your
the
time,
floor and
counsel, because I've got a question about what we do, or if you have any cases that what our standard of review of what the court finds factually, how the lack of a Trinity hearing impacts that. I was struggling to find guidance on what that does to our review. What's the best case for that? Or
the case is in front of me, but I believe as we cited in the very first part of the reply brief, you can't have findings of fact without a hearing. And so I think what this court has to do is look at, if we take the undisputed facts and they give us a clear answer, then we can answer it.
is it any different than a summary judgment standard? That we take all facts in the light most favorable to the non-prevailing party? Or is it different than that?
I think the cases say when you decide it without a hearing, you have to assume that the allegations and the facts presented by the non-moving party are correct. Now, that doesn't mean you couldn't hold a hearing later. So this court could remand and say, considering plaintiff's facts in the complaint and what they submitted in response to the motion, this is a dangerous condition, but those could be disputed, and so you need to have a hearing on that. I think that is a potential answer that this court has if it's concerned that those facts could be disputed. And if there aren't any follow-up on that, I'll reserve my time unless there's a follow-up question.
Thank you, counsel. You have about 2 minutes left.
Thank you.
May it please the court. Good afternoon. My name is Mark Cloart. My Colorado bar number is 29892. I'm joined by Adrienne Toon, who's at the table. Her bar number is 42984. I believe this case is a good example of why the legislature enacted the Government Immunity Act in the first place, namely to prevent public entities from becoming insurers against the commission of any type of tort on their property. Here, the legislature provides immunity, as we all know, unless there's a dangerous condition. And the exception sought here is a dangerous condition of an accumulation of snow and ice which causes injury. And that dangerous condition must be an unreasonable risk. And just the mere existence of snow and ice doesn't constitute a dangerous condition. In fact, the Supreme Court recently held that a plaintiff in the Mathis case, which was referred to a moment ago, that a plaintiff must show that the condition must create a chance of injury, damage, or loss which exceeds the bounds of reasons. Now, why do I say this is a good case or a good example for why this statute exists and provides immunity? Because if we look at the facts that were undisputed, I represent the two appellees. I should have mentioned that Montrose County Board of County Commissioners and Montrose Regional Airport. And when, if I may, I'll just refer to them as Montrose. When Montrose filed its motion as to the amended complaint, it didn't state that there were any controverted facts. And instead, to Judge Welling's question, I think that the court can take the as pled facts at that time as true for purposes of deciding that motion.
But the court drew some inferences for those facts. So, and I guess that maybe is more of my question. There may not be, you may be right, there may not be disputed facts, but it seems as though some of the inferences that were drawn from those facts were drawn in your favor as the prevailing party with respect to the thickness of the ice or with respect to the visibility of it due to daylight. And in fact, made some findings based on these pictures. And I'll be candid with you. I can't say with 100% certainty where the ice begins and ends. I mean, the allegation is, as I understand it, that it's all the way across, so a restricted area. But how far up and where the meets and bounds of that are is not apparent to me, and and we came to different conclusions within my chambers. So for whatever that's worth. So what do we do with that if it's maybe not undisputed facts, but the inferences that can be drawn?
And I don't have a case site for you. I would posit that a reasonable inference could be drawn from the facts. And I wanted to point out one fact. On page 254 of the record, it's the first page of the declaration of the plaintiff at paragraph 6. She says the photos appear to show the ice going across most of the path. So I would slightly push back on the suggestion that there was an ice patch covering the entire path, because the plaintiff's own declaration suggests otherwise.
Seems like something that could be fleshed out in a hearing as to whether or not there was some passable portion that wasn't covered by ice.
And again, I think that's perhaps the movant's prerogative, and the movant in that case, my client, didn't make any assertion of uncontroverted fact. I think it would be acceptable to accept the plaintiff's own statement or admission there.
Could I follow up along that same lines? Let's say the facts were that it was thick ice, as the plaintiff says, and it were dark, and it covered the entire walkway, and the employees had to stay within the walkway. Would that constitute a dangerous condition?
Well, first recognizing that's not the facts of this case. And perhaps at times, I think it would depend on the circumstances.
Okay, and if it depends, and the plaintiff is disputing those things that I just said, then why does that not warrant a hearing to resolve those things? Like, was it light, was it dark? Was it thick ice or thin ice to the extent that matters? Did it cover the whole thing or just a piece?
I think that should have been something that would have, should have, could have been raised by the appellant in the pleadings in the district, before the district court, and they weren't. Many of those arguments weren't raised until the pleadings in this case.
But some of the facts that were found were the trial court freelancing. Nobody raised the lighting conditions, but that was a pretty integral finding. So it's not like this was a failure to plead this, or you raised it and they didn't rebut it. The trial court here was kind of just taking some prerogative based on the information that was before it. And why isn't that the sort of thing that the court should have resolved in a hearing as opposed to here at the pleading stage?
Again, I think the district court, based on the facts as she saw them and as pled by the parties, could take those reasonable inferences. I don't think it's unreasonable to infer that light was, or ice was visible at the time, which was represented as between 6:30 and 7 in the morning.
Counsel, it was 6:30 and 7 in the morning on February 24th, okay? The court just said there was enough daylight for plaintiff to see the ice, but it could have been 6:30 in the morning on February 24th, which appears to have been before sunrise. That sounds like some fact-finding outside of anything in the record. Certainly not the kind of thing that you can take judicial notice of.
Well, and I think that inference, to the extent it is, could be bolstered by again, record 254, the declaration where it was said that she noticed some snow in front of the building.
Again, we don't know if the front of the building was lighted, whereas the walkway where she slipped was in an unlighted area. I mean, there's there's a lot we don't know. And I guess the thing that I'm also struggling with goes back to what's our standard of review when there's no hearing and there appears to be things that look and feel a lot like factual findings. And do you have a familiar rubric for us to go back to? I mean, the one that I want to go to instinctively is a summary judgment. And that to the extent that we take the undisputed facts, we draw the inference against the non-moving party to determine. Otherwise, if you can't do that, then you have the hearing and the court gets to make the factual findings. I'm also not used to deferring to a court's factual findings that is made without a hearing.
Yep.
Should we be deferring to them, and what's the standard in your view?
Well, I think twofold. I think in the case of a motion to dismiss on the basis of governmental immunity, it invites, and in fact, requires the district court to make factual findings. That's number one. And number two, if you look back to the non-movement's response here at record page 199, she in fact says she believes she has presented sufficient evidence to find a waiver. So she does say if the court wants a hearing, then go for it. But there wasn't a per se, yes, we definitely need a hearing to clear up disputed facts.
Well, both sides say you can look at the evidence and without a hearing you can rule for us, or if you're not going to rule for us, you need a hearing. And that's also typical in summary judgment. And that doesn't mean that when both sides say that, the court can just resolve the case on the papers. Usually what that means is the hearing is necessary. And particularly in this context, factual findings are required. Shouldn't it be when there's things that look and feel like either dueling facts or dueling inferences from those facts, shouldn't the strong presumption be that the court just has a hearing so that it can then exercise, do what it's best at doing?
Perhaps, but I think there's strong language not only within the statute, but also case law that again reiterates that just the existence of ice without more is not enough. And here, I'm not understanding what more there is here that would push it over into the exception category.
And I think it gets to maybe some of what Judge Schock laid out, as well as the earlier discussion, which is it covers the entirety of the walkway. It's difficult to see, it's dark, and it was unreasonably dangerous because failure to comply with regulations to take care of it within an hour. And those are at least allegations that are on its face supported, maybe won't be ultimately able to be proven at a hearing, but it's been sufficiently pleaded such that the court, if it's going to disregard those, needs to do so with a hearing. What's your response to that?
Again, I think when you look at it in the context in which the district court did, given the legislative mandate in terms of the facts that are required to push it over the edge, if you will, to permit an exception, I think that what the district court did here, obviously, perhaps subjective opinion, was appropriate.
Can I ask you a factual question or factual clarification question? Was this walkway only for the use of the employees of the airport, or was it the one that the passengers used, and does that matter?
I believe it was for all, and also not in the record is that anyone else slipped or anyone else had an issue. You know, there was a curious point, I found it curious, in the appellate pleadings of the appellant that there were cones set out, and that was indicative of a risk, which, you know, as I walked in the courtroom, there's no cones here, which tells me there's no risk of slippage. If there are cones set out, perhaps that should have been a signal as well. Again, that wasn't raised below. That was one of our arguments, so I suspect I shouldn't have just raised that here. But
that gets perhaps settled in as part of a hearing, because as I look at the pictures, the cones appear to be at the yellow line. So perhaps cones are always there so that everybody knows exactly what the confined space is, or perhaps they were put out because they were concerning conditions and this should have alerted. To me, again, that seems a lot like like a hearing issue. I guess the case law says the trial court has discretion to hold a hearing. When and how is that discretion, or what would you say, I guess, to us writing that it's an abuse of discretion to not hold that hearing when there are material issues of disputed fact?
To me, again, I'm going to go back to the legislative statement that just the mere existence of ICE. And to me, there was nothing else here pled other than the existence of ICE. There was no pleading of violation of FAA regulations. There was no pleading of violation of any airport snow removal plans. It was just simply plaintiff walked across, slipped on ice, fell, and had some injury. And to me, that wouldn't raise the specter to me of anything unreasonable. For example, it had snowed 12 to 14 inches the night before. It had been 67 degrees the day before and melted in a torrential river of water that then froze overnight that covered the path. There was no, if you read the amended complaint, there's no exotic pleadings like that. It's a very bare bones complaint, which again, to me, just doesn't, when you look at the statute, doesn't raise the specter of unreasonableness, and perhaps then tipped the judge to not do a hearing in her mind.
Counsel, in the 12B1 context, as opposed to the 12B5 context, the court isn't stuck with just the complaint. The court can look at other documents and materials that are submitted afterwards, and it appears that's what the court did here. Would you concede that?
I would, and to that point, if you look at the documents attached to the declaration, it indicated there was snow. I think this occurred on February 24th, the week before on February 17th, at 0.05 inches. So less than 1/10 of an inch. And in the intervening days, at record page 259, it shows that the temps rate went all the way up to 67 degrees for a high. I've lived in Colorado for 47 of my years, and I know that 67 degrees will melt less than 1/10 of 1 inch. So certainly that could have played into her basis for making the inferences she did.
But I'm not seeing how that's really all that relevant. I mean, there doesn't seem to be a dispute that there was ice there. I mean, those facts just all go to how it got there. Okay, so there's ice there. The question before us is, are there facts in the record that would show something more than, as you say, an accumulation of ice and snow sufficient to waive? And maybe in this context, sufficient to justify a hearing.
Yeah, and I think another fact that can't be ignored, going back to the plaintiff's declaration, is she said it covered most of the walkway. So I would disagree with the contentions that have been made that the plaintiff had to walk through and over the ice instead of around it.
But I don't know what she necessarily means by most of the walkway. It could have covered completely across at some area, but not the entirety of the walkway. Then it is still, there is an area that you have to traverse the ice. Or it could have just covered the left half, and in which case then it's not the same thing. But again, we don't know that from this, and I sounded like a broken record, but I guess my question is, why doesn't that require a hearing to sort it out? But
Understood. I see that my time's up. Thank you very much.
Thank you, counsel. Mr. Davis, you have 2 minutes left.
Thank you, Your Honor.
And actually,
Congrats.
can I start and ask you kind of a big picture question that's bothering me a little bit? And it's that I know you want to look at the Galef case and you talk about Martinez, but it seems to me that the Supreme Court in Mathis and Dennis has set a pretty high bar for what constitutes a dangerous condition. You know, even things that can and did cause very serious injury. I mean, potholes in the street where somebody got, very seriously injured, the sidewalk. And they say it has to be one that exceeded the bounds of reason. And so tell me how, and maybe you've already done this, but ice on a walkway in Montrose, Colorado during the winter exceeds the bounds of reason.
Yeah, looking at this particular case, if you look again, the factors in Martinez, but then also the subsequent Galef case, which came after Mathis, you have ice you have to walk across in an area where you know people are going to be walking. And it's a high priority area, which differentiates it from a residential sidewalk. You have as was discussed in Galef, you have a risk of serious injury from fall on concrete, just like you have a risk from a fall on stairs. You have it being essentially the sole cause of the injury in this case, at least as alleged, or the major cause of a significant injury here. And it's not just from Ms. Scott's injury, but we've also cited cases where significant injuries were found in related cases. You don't have an issue, going to the reasonableness, you don't have a practical impossibility of keeping it clear of ice because it's required by regulations and by policies, and we did cite the policies in our response to the motion to dismiss and attach them. You don't have a high cost. You don't have to worry about prioritizing because it's already a priority. You have like a stairway, you know people are going to be using it, just as you know people will be using the stairway in the Galef case. A big difference though is if you're in a stairway, you have a wall or you have a handrail you could try to grab onto to stop your fall. You don't have that when you're walking across an icy sidewalk. You just have the sidewalk, and that's what happens. She tried to catch a fall and she hits her wrist. And so we allege those things, we put them in there, and that's what really differentiates this case. And if you look at the Mathis case, they talked about this might be a different result if the fall was in front of a school or a hospital. In this case, it's more like that. It's a high priority area. It's an area where you know where people are, and there's a high risk of injury to those people.
Thank you, counsel. Your time is up.
Thank you.
Thank you to both counsel for your arguments this afternoon. They'll be very helpful to us in resolving the matter. The case will be deemed submitted. We have no other cases on the docket this afternoon, so we'll be in recess and the bailiff may so announce.